Welcome. We're here for the jury nullification panel. My name's Leah Wolzkom. I'm from Goffstown. I'll just pass this down and let everybody introduce themselves really quickly, and then we'll get started.
Hi, I'm Bill O'Brien.
Hi, I'm Bob Constantine from Grafton, New Hampshire.
And I'm Kathleen Converse from Barnstead.
So we have two movers, two free staters on the panel, and we have a native. This was the Speaker of the House. He's still a current representative. And I'd like to start back in time with jury nullification. So the jury is supposed to be the conscience of the community. And if the law was not what the people that were there thought it ought to be, that was the firewall. And I'd ask if you could give us any examples of, just really quickly, of how that played out historically.
Thanks, Leah. One of the first things I want to just make clear is when Leah said I was a native. Actually, I'm not a native. There was a fundraiser that the Democrats had 2 or 3 years ago, and Jean Shaheen asked Deval Patrick to take me back to Massachusetts. And so one of the things we did was look at the New Hampshire legislature. This is when I was Speaker. We found about 65% of the New Hampshire legislature are people born outside of New Hampshire. So this is a very welcoming state, and I appreciate you welcoming me here to your meeting, to your weekend. One of the things we have to, I think, understand about the genius of what developed over centuries in English law was a journey from absolutism to a parliamentary government, a government of checks and balances. And so that really became embodied in our Constitution. I think we see it that there were horizontal checks and balances, I call them, between the judiciary and the executive and the legislature, each having, and our Constitution, New Hampshire, is pretty explicit on this. It says each will have a negative on the other. And then you see in our federal Constitution that there's a vertical checks and balance, or at least they should be. It's been lost over the last many years, probably since the Federal Reserve was put in place and the direct election of senators and income tax and all those I'm sure you're all aware, played into making the federal government more powerful than it should be. But the theory was there'd be this check of sovereign states on a federal government. And the reason I bring this up is because that development of this journey from absolutism involved the use of jurors in our judicial system. There'd actually been, in the past, a number of different ways that the court system would attempt to determine the guilt or innocence of someone. I mean, at times they'd even go so far as, dunk them in some water and see if they'd survive underwater for a while. If they did, they'd be innocent. Or could they walk across some coals, and if they could do that, then, they're innocent. And, I suspect even at the time that seemed sort of foolish. But what they hit upon was having lay people, having people come in and be the judge and jury in a case. They had judges. The judges, in many ways, in the original conception of a jury trial, were to be kind of the administrators of it. And so we had grand juries, and actually the term is petite juries, trial jurors. And each of those were supposed to bring the conscience of the community to the case. And we saw that in early cases in our country. There's a famous case that we as lawyers study on First Amendment rights. I'm trying to remember the guy's name. His last name was Zinger. I think it's Peter Zinger. Peter Zinger was tried back in the 1730s for defaming the monarch. And he was tried in Boston, and apparently Boston, they didn't really care about that so much. So even though the judge instructed them, if you find he said this, you will convict him, it took the jury about 10 minutes to say, we find you said it, and we're not going to convict him. And so too in our Supreme Court. One of the things that people don't realize about our Supreme Court is that it's a court of original jurisdiction for certain types of cases. It's a court of original jurisdiction for cases between states. And in point of fact, back in 1794, it actually had a trial jury. It brought in a jury and tried a case involving a state. And the instruction given to that jury by the Supreme Court Justice, the Chief Justice of the time, I think it might have been John Jay, was listen to us, we'll tell you what the law is, but in the end, decide on your own what law should be applied, how it should be applied, and the facts of the case. So it was recognized that there was this role of trial jurors to not just be people who determine facts, but determine law because they're bringing the conscience of the community to the case. Over time, you know, as governments tend to be, and as participants in governments tend to be, we saw judges get a little bit more arrogant about that and say, no, we decide the facts. And you get instructions now where judges will say, we decide the facts, you cannot, we decide the law, you cannot ignore the law, you determine the facts. And we saw that didn't work so well in some situations. For example, a famous example of the fugitive slave laws back in the 1850s, as part of the various compromises between southern states and northern states in the Congress, they passed a law saying, federal law saying that anyone who is harboring a slave escaping from the South can be convicted of a crime. What they found, though, is even with federal jurors in northern states, they would go in there and the federal jurors would just say, we're not going to convict. You know, that just, it shocks the conscience of the community. Now, so you fast forward to New Hampshire. You want me to get into New Hampshire and what we did here? Sure. So you fast forward to New Hampshire, and I've been in the legislature pretty much since 2004, and was on the Judiciary Committee in 2007, I think it was. You might know better, Bob, because I know you were there for the hearing. And there was a hearing on a bill that would require judges in New Hampshire to instruct jurors that in the end they can decide, even though they may decide contrary to the law, whether they want to convict. And we had an interesting hearing on that. The bill didn't pass that year. Those who would support it were in the minority at that point. But we had an interesting hearing. Judge Lynn, who was at the time Chief Judge of the Superior Court, the main trial court in New Hampshire, was testifying in front of us. And you know, I've had a history of being a trial lawyer where I have to please judges, and it's really quite fun to see if they can please me when I'm in the legislative hearing. And so I was questioning him pretty tightly, and finally he admitted that it is intrinsic in the jury system, and they have every right to ignore the law to bring the conscience of the community to a case. He said, we know they do that, we don't like that they do that, we don't want to tell them that they can do that, but it's constitutional when they did that. And so he counseled against us passing the bill that cycle. Come 2010, I became Speaker of the House. The bill was filed again, and we were able to get it through at that point. We didn't get it through in the form that we wanted it to. The way we wanted to get it through is to have a judge instruct the jury that they have a right to apply their conscience, apply their community sense to whether or not a conviction should take place. So even though they would look at the law and say, you know, that's the law, we have no misunderstanding of that, look at the facts and they say that those facts should amount to a conviction under the law, they nonetheless, and they would be instructed that they could nonetheless not convict. Now the bill had a pretty tortured journey through the legislature. You know, as Speaker, you're sitting there kind of shepherding along and looking at, 900 pieces of legislation at any given time, and you're doing that in the context of the first half of trying to put a budget in place, and at that point we were trying to reduce spending. We were running out of money in New Hampshire, so we ended up putting a budget in place that reduced state-funded spending by almost 18%, so a lot of attention paid to that. And I happened to be preparing one point for a session day, and I noticed that a bill that had come up and should be on the calendar was this bill, and it had come out of Judiciary with, I think it was a unanimous recommendation not to pass it. And that wasn't good. And so, so we brought in some of the members of the Judiciary Committee and brought in some allies, Dan Itza, Representative Dan Itza from Fremont, I guess. And when it got to the House floor, we moved to recommit it to the Judiciary Committee. They heard it and heard different things, I guess, because it came out of Judiciary Committee with only one vote against it. They reversed it and came out. It passed in the House, went over to the Senate. Senate was a little bit of a difficult journey. They first did the same thing, decided that they weren't going to pass the bill. As Speaker, you have probably less influence on what senators are going to do, but you have some influence on what they're going to do because they like to have certain things passed. We like to have certain things passed, and so we talked to them. Eventually, they reversed themselves. Actually, we referred it to their committee again, and we managed to get it out. They did make a change on it, and Bob and I were just discussing. It's not the most ideal bill. What we would again like is a bill that would require judges to instruct jurors that they have a right to apply their community sense. The way the bill came out, and I think it's useful the way it came out, is as defense counsel or a defendant can tell the jury that they don't have to convict. They can find that the law was violated, but nonetheless, they do not have to convict. And so it's a step forward. I hope at some point we'll have a majority like we had this past term in the Hampshire legislature. We can move it forward. But it's useful. It's useful in the immediate sense for those who will go on trial. It came into effect January 1st of this year?
2013.
Through 2013. And so it has some effect in our courts, but it also has some effect nationally because, one of the things I found as Speaker, you go around and you go to various conventions, you speak around the country, is people are bringing it up, they're mentioning it. So I think others are paying attention to this, and it advances this understanding nationally.
And just as an update to this, because I too was confused why we would have a law that said that the defendant can argue this, but the patent jury instructions, the sort of boilerplate jury instructions that are given in every case, says the opposite. It literally says, regardless of what you think the law ought to be, the law as I give it to you is the law you must apply in the case. So it conflicts. And the jury is further told it doesn't matter what the defense attorneys say. They're not witnesses. They have no say. So I talked to Mark Sisti, who was the defense attorney in the case that Kathleen's going to speak to you about. And luckily for us, it actually isn't as dire as it sounds, because back years ago now, there was a trial that was decided at the Supreme Court in New Hampshire called State versus O'Bear. And it was a woman who was on trial for killing her husband. And she claimed it was an accident. And she put some little bit of evidence in that it was an accident. The judge refused to give the instruction on accident, because there's specific law that the jury's to be told to find if something was an accident. That case was reversed. And the case that came out of that said, if any evidence is offered at all by a defendant in a case, the judge must instruct on the law that applies. Well, this law applies now. This is the law in New Hampshire. And we just had a case out of Keene. I'm sure some of you are familiar with it, that the judge refused to give the nullification instruction. So Rich Paul's case may very well speak directly to this law, and we'll find out if they're going to say, yes, it is the law in the land in New Hampshire that you must give instruction whether you like it or not. So hopefully we'll keep our fingers crossed. Going back in time before the bill was passed, I know that there was work done in New Hampshire, and the Fully Informed Jury Association had a spin-off, a New Hampshire version, which I think Bob was involved with. And if you could
Sure.
talk to us about the work you did with that.
Well, nhjury.com is just that, a spin-off of Fully Informed Jury Association, or FIJA. One day, some of my friends and I were sitting around, and we said, we really like FIJA, but it's just, people say, FIJA, what's that? Is that an island in the South Pacific? So, we got thinking about how could we do this better, so a Google search or something might draw people to this. So we said, well, what would we call it? And what if we did our own brochure? So first of all, I'd like to say that FIJA, they're doing a great job. We're not competing with them. We're admiring them and saying we're going to do our own version here and basically advance the same ideas. So we sat around and we came up with all these brilliant ideas because we were already doing outreach. We were getting up in the morning, going to the courthouse once a month and handing out juror brochures and so forth. And then we thought, well, we'll get something, and we came up with this, which maybe many of you have seen. One of the things that I think the question that's come up is, well, how effective have you been and how can you measure that? I really don't know how effective we've been. All I know is that, you know, it's a journey that the more people hear about this and the more, each time you get a small victory, it's sort of got a ripple effect. A couple of things that I may want to touch on later are how you combat the system in the sense that it was referred to the standard instructions, those are known as the Wentworth instructions. They're a little bit ambiguous or maybe even leaning towards favoring the state. So I had a trial myself, and what I did with the support of some of my friends is I said, what do I need to do in order to convince this jury? Well, the first thing I have to do is erase what the judge is going to tell them. Because when you're in a trial, there's this invisible line between the judge and the jurors. You know, Kathleen will probably touch on this later, but you're a juror, you walk in, hey, where do we go? What do we do? Oh, they're going to make us sit over here, we're going to do this, we're going to do that. I've seen this. So when we get to that point in this discussion, I want to talk about how I gave my closing argument and how I would recommend to other people to give their closing argument, because naturally you don't want to piss the judge off, but you really want to sell to the jury, and you want to get to their conscience. So as far as NH jury, there's a lot of information there. I'll pimp it a little bit now. We're looking for people to help us because I'm not the greatest guy getting online and posting stories and all that. My friend Rich Angel is down in Ecuador now. He was doing a lot of that. So if there's anyone who's at all interested in advancing this, see me after, because you can become part of NH jury. And, you know, it's ours.
So Kathleen, a Free Stater, amazingly gets called for a jury for a Rastafarian who's growing pot outside his house. And this is after the law is passed, but before it goes into effect. So Kathleen, tell us about the trial and what happened, how the jury instructions went, and what took place in the jury room.
Well, I was called for jury duty and have not been in many years, and certainly this is the first time in New Hampshire. We've been in the state 9 years now. We'd been in Barnstead for almost 4 when I was called for jury duty. So I, you know, was wondering what I was going to be faced with, and I went to Laconia, and when I was placed on the jury, we went through a voir dire, you know, as all jurors do, and that is the place where they try to weed out someone who has biases. And I, you know, wasn't trying to manipulate my way onto a jury or anything of that sort, so I honestly and soulfully searched after every question whether I could answer it honestly to myself, and they were very extensive, but they all had the same goal. All the questions were, do you have any experience, knowledge, associations, beliefs that would make you biased in this case? And I, being a libertarian, being a free stater, you know, I of course believe no victim, no crime, but I also know that realistically I probably could be faced with circumstances in which I could convict somebody. If I, you know, felt they were a real danger to the community or something, you know, I wouldn't have any trouble convicting. So I never felt like I was going to be a biased juror. So I was placed on the jury panel, and we were introduced to the defendant and the defense attorney, and I had never met these people, had no knowledge of this case in any way, which is surprising because he lives down the road from me. I recognized the house. I'd drive by this house, and it became an issue. So they conferred about that I was a neighbor, but none of the other jurors felt that I would be biased or anything, so I was allowed to remain on the panel. But here I was, a juror, being faced with a perfect defendant. You couldn't ask for a better defendant. And they never presented any evidence of, of any sort that would make him a danger to the community or any, and there was no denial of what he did. He was, manufacturing a controlled substance. And it all came to light with a military helicopter at 400 feet, photographs and, a big raid and so forth. And so we had the plants in the jury room, and there was no doubt what it was. And he got on the stand himself and said, yes, I thought I was protected under the law. I am a Rastafarian. I have been doing this for 30 years for, health and sacramental, reasons. And during this testimony, as a juror, I was waiting for some sort of confirmation, but they didn't want to go into a First Amendment issue. Did he have religious, freedom in this way or not? I don't know. So it was never presented. So we didn't have that to go on. But the defense attorney Sisti, very clearly asked for jury nullification. And the prosecutor, in closing arguments, tried to downplay it. Oh, it doesn't really apply in this case. That's for, really dangerous, important life or death kind of circumstances. It doesn't apply in this case. He did it. He said he did it. We proved he knew what he was doing and what he did. Therefore, you have to find him guilty. But during the instructions, the boilerplate instructions are very lengthy, and they're even confusing in themselves. And at the very end, the defense attorney whispered to the judge, powwowed, and got the judge to confirm what jury nullification was and that we have this right. So when we went to deliberate, it seems kind of odd, but the other jurors were still unclear as to what jury nullification is and what right they actually had. What is this jury nullification? Well, having some knowledge, I said, well, I know what it is, and I explained my, understanding in a layperson's manner, that if we don't, that if the facts are he did it, but if we don't feel it's a right conviction, that we don't have to convict him. We still took 2 days of deliberation talking about his intent and criminal act and so forth with 12 of us before. It took many hours before we even discussed nullification. We were discussing the facts first, and but when we finally decided to discuss the nullification, we went round and round and round with a whole range of jurors from all walks of life, as you can imagine, all walks of life, from the hard-nosed, conservative law and order person to a fairly liberal live and let live kind of people. So they were all on there, and it took many hours, but it was kind of a shock when we got to a point where we went around the table and the first person said, oh, he did it, but I could nullify. And the second person used the same words, oh, he did it, but I can nullify. So by the time it went around, I was surprised that the entire panel said they were willing to nullify. I was fully prepared to hang this jury, and I figured I would have to. But they did. So we came back with not guilty, and I'm pleased. I'm surprised that I had no prior knowledge, did not know this man who lived down the road or what he was growing in his backyard, and that we did see that justice was served, thank goodness.
So, Kathleen, it sounds like two things were necessary for the way it played out. One was you needed the judge to tell the jury. If Mark Sisti had said, you have this right, and the judge had just gone with that boilerplate instruction where he said, you have to take the law from me, do you think that it would have come out the way it did if the judge refused to bend?
I think it took everything. I think it took Sisti, who was wonderful in his presentation of what nullification was, and I think it took the judge's confirmation, but I also think it took my understanding and explanation in the jury room, and it took an awful lot to legitimize it in the eyes of all of those jurors. And there's one more thing that did not come up in the jury room. I suspect there were pot smokers in that room. I mean, statistically, and all these quiet men who wouldn't open their mouths, I suspect, and so they were empathizing in some way. That, and I think it took all of that for them to say, we can't do this to this man.
So that was the second thing I was thinking was necessary as I listened. They needed to hear the judge tell them that they had the right, because they asked for that, right? They had a jury question come out.
We asked for clarification. We asked for instructions again. We asked for the wording of the nullification, the way it was presented to us, and it took hours of discussion.
And you needed a sympathetic defendant. So they had sympathy for him for a number of reasons.
We couldn't ask for a better defendant.
Some of them may have just plain identified with him because of a shared interest in a certain vegetative matter. Others may have felt he was doing it for his religion. Others may have felt, I don't like black helicopters flying overhead. Others may have felt he wasn't selling it to anybody's kids. He wasn't hurting anybody. So you need a sympathetic defendant. And this leads me to a question that I have for Speaker O'Brien. When I spoke to Mark Sisti on the phone, prepare for this, he said the same thing. You absolutely have to have a sympathetic defendant. And I'm reminded by the fact that the Chief Justice of the Superior Court, when he came before your group, he said, we know they have this right, but we don't want to tell them that they have this right, because he had a fear of something. And you admitted when we spoke that you understood that fear, that there wouldn't be an equal application of justice under the law, that sympathy for one person and somebody else is not as sympathetic would end up in two different answers with the same fact pattern. Could you speak to why, even though you had that fear, you thought this was a good bill anyway?
Well, you bring up two issues here. One is that this approach works very well as what we argued before the legislature and in committee and legislative committee is what I call the canary in the mine approach. It tells us, legislators, courts, that this law doesn't have community support. That's what happened in the fugitive slaves law. It signaled the fact that the sense of the community was changing when it came to slavery. And so too, the fact that the application of this law, and particularly cases involving the use of marijuana, is going to, I think, have increasing success, not only will signal to legislative groups or legislatures that these laws don't have the support of the community, but they're already doing that. We've already passed a bill in the House this session that would loosen laws. And I've seen many of my colleagues that I've been working with over the past 10 years make a journey when it comes to laws dealing with the use of marijuana from, no, we don't want to do it, I don't do it, I want to keep people from doing it, it's awful, to to, quite frankly, where I am, which is, no, I don't do it, but it's not for me to dictate on a harmless activity like that as other people's behavior. So I think it has a laudable effect in that sense. The concern we have, the concern that Judge Lynn had, and the concern that many have, is that allowing this approach to the decision to acquit or convict will introduce a greater opportunity for discrimination. Understand, if you would, that at this point, if you're a male who reaches the age of, I think, 54 or 55 in the United States, and you're a white male, there's only a 3.3% chance that you've spent time in prison. If you're a black male, there's a 20.6% chance that you have spent part of your life in jail. And so many, and I think Judge Lynn, I think many, certainly I mentioned before the arrogance of position, and that happens when you get into government. There is an arrogance of position, but the concern they have is that some people look attractive to jurors and others don't look attractive. In Hampshire, we don't have a large African-American community, and we want to make sure that if an African-American man comes before a jury here, he's going to be treated just like some old white-haired guy from my town of Mount Vernon. He's going to be treated well. And if he's using marijuana, he's not going to be convicted any more readily than I would be convicted. And so that's a concern they have. So much in what we do in government is balancing these interests. I think the best balance is to follow what the reason we have jurors. And we don't, in other countries, in civil law countries, they have professional jurors, they call them magistrates, and they decide facts, they decide the law. Here we have our neighbors, and we ought to continue to follow the logic of that while being very careful to avoid this discrimination.
I'd like to follow up on that. I think for me, the easiest way to ensure that it's fair is make sure the judge instructs all juries that they have the right to nullify if their conscience tells them that they're doing the right thing. I may be getting this wrong because it's been a while since ninth grade Latin, but something that's a malum prohibitum, which is basically legalese Latin for because we say so. If the defendant has created no victim, well, then those laws are wrong. So I cut right to it, and that's when I'm explaining jury nullification to someone, I say, look, if they've got somebody up there because they were selling raw milk to their neighbor, or they were, engaging in activity that you might not, but that is harming no one, it's an easy thing to do. All you have to do is say, well, wait a minute, I don't know where the victim is. Oh, wait a minute, the victim is the person in the defendant's chair. That's an easy one. To me, I just cut right through it. No victim, no crime. That's what it says. When we get to the appropriate part, I would like to talk about some of the things we're talking about, the standard instructions. I think those are known as the Wentworth instructions, and they're kind of what the judge runs to in a lot of cases, and they're very ambiguous. And I think it's important, if you are a defendant or a defense counsel, to inform the jury of some of the slippery language that's in there. And I think it's very important to understand how to combat that.
As far as the instructions go, and the way Defense Attorney Sisti explained it to us in the courtroom was very, very well. He said, you are going to be given instructions that say, if the prosecution has met the burden of proof, you must find him, if the prosecution has not met the burden of proof, you must find him not guilty. But if the prosecution does meet the burden of proof, you should find him guilty. And he said that difference between must and should is a crucial one. It allows you the option to say, even though all the facts of the case are that he's guilty, you can find him not guilty because you have a slight write in the standard instructions. Should instead of must.
Right. That's the part of the jury instructions that's probably like 30 pages long when you transcribe it out. That's called the Wentworth instruction, that little tiny must and should. It's read very quickly. It's a sentence out of 35 pages of material, and it's usually totally lost. I think we have a question.
Yes, before we leave the subject of the judge's worry and your worry that somebody will be given unfair treatment, the judge also has the privilege of nullification. If a black juror were being treated not like a black defendant were being treated unlike a white defendant, the judge, even if the jury comes back with a guilty verdict, can nullify that.
Thank you.
I'm not aware of that. I don't think that's the case. The judge can find that the state didn't prove one of its elements of the case and throw the case out. They can even do it after the thing is all over, but I don't think they can do it on a nullification basis. I don't know, though.
Just as the defense has a right to appeal in a criminal case, the prosecution does. And I will tell you to a certainty a judge would be reversed if the judge were to say, I'm just going to nullify, I'm going to ignore the law and nullify this decision. The jury has the ability, because see, the thing is, we don't look into jury deliberations. We don't care what they say in the jury room unless, except for very, very limited areas. If there's evidence they engaged in fraud, someone took a bribe, or there's evidence they engaged in discrimination, I'm going to convict someone because he's an African American, the court will accept testimony. But other than that, the court doesn't want to hear about what went on in jury deliberations. And so if everyone said, we just don't like the prosecutor, and so we're not going to convict this person, there's nothing the court can do. But everything the judge does is on the record and reviewable. And if a judge were to say, law was clear, facts were clear, conviction was clear, I'm going to reverse, that judge would be reversed on appeal.
I was on a jury many years ago in another state in which, after, plenty of testimony and even closing arguments, the judge threw it out, saying you made no case. And I think that I think that's the point he can make that. But
he'll have an appellate court looking over his shoulder,
yeah.
And the standard there is that no reasonable jury could have found as this jury
So
found.
we were never even sent to deliberate, of course, because he said you've made no case. You said it was going to be a negligence case, and you brought no testimony regarding negligence.
Right. I mean, there are elements of every crime, right? So arson has these 5 things you have to prove beyond a reasonable doubt. If the prosecution fails to offer any evidence that a reasonable jury could find was the fact, if they fail on any one of those, then the judge is supposed to throw the case out. Yes, sir.
What you're talking about is meeting a threshold of evidence to be able to present to the jury. If they haven't met that, then it gets thrown out. But that's not why I come up. Basically, to make this very simple, every case has 2 defendants, the alleged defendant and the law. And you can find the law guilty or the defendant guilty. That's basically what jury nullification is about. Because the law is on trial each and every time. Every law is on trial. If the jury doesn't like the law, it's not just law, they can find the law guilty. And that's how the law gets nullified eventually.
I think that's an excellent point, and thanks for bringing that up. The difficulty that we have, and that I want to put out there to everybody else, is getting everybody to know that. Because when you're a juror, certainly the prosecutor's not going to tell you that, and most times the judge isn't going to. So, great point, but what our work is to make that common knowledge.
I think that's an important point in trying to get these laws in place in states, because when they are faced with a bill that will, make this an easier process, the legislatures are told, yes, we will be judging the law that you are making. You might be put on the spot to defend why you passed this law. And in every case, it could be a very expensive process to actually defend the law, and the prosecutors don't want to have to defend the law case after case after case. So I think that's why it's tough to get these bills even passed. You know, the legislature feels like they would be put on trial because they passed the law in the first place.
That's a good point. There's actually some quotes in here about some legislators who were against the bill passing. And I attended some of the hearings the years that the law didn't go through, and I tend to be a bit of a cynic, so I think what it really comes down to is people gain these little areas of power and they're very reluctant to give them up. I don't know if this is an appropriate time, but when it comes to a closing argument, the Wentworth instructions, as Kathleen mentioned, they use sort of weasel words. One of the things they bring up also when they instruct you is they'll tell you that your verdict must be unanimous. Well, that's if you reach a verdict. You as a defendant or you as a defense counsel, one of the points you want to make is there's such a thing as a hung jury. So you want to stress that. You also want to tell your jurors the jury is not a democracy. A single juror, just like Kathleen pointed out, she said, hey, I didn't have to really keep everybody there for 3 days because they all came around. But she was willing to do it. And that's an important point. Because, again, these jurors, they're off the street. They're schooled to be obedient. So you want to say, if there's a verdict, it must be unanimous, but hung jury. Not a democracy. You also, if you have a felony level charge, if you're the defendant, you can ask for something. It's called lesser included offenses, and Bill probably knows more about it than I do, but basically you can say, well, if you don't find me guilty of the felony, you know, maybe you need to go home with a little bit of blood, so, hey, hit me with a misdemeanor, something like that. So it's a tactic that you can try if you're a defendant or a defense counsel. The other thing that essentially during this whole thing is you want to be polite to the judge and all that, but if it's a jury trial, you're selling to the jury. So you want to always be aware of that. You want to talk to them. You want to come across as a human being. One of the things that I did was I pointed out to jurors, where's the victim here? You want to ask the jurors if they can identify a victim. And the other thing is, and maybe it wouldn't happen so much in New Hampshire now, but until this law passed, some judges would prevent you from using words like jury nullification. So then you want to say, well, let's find a way around this. Then you go to the right of conscience, which is Article 4 in the New Hampshire Constitution. That's what I spoke about. You have this conscience, all that type of stuff. The other thing you could do is you could visit nhjury.com and see this video of a closing argument. But those are the points I wanted to make, because if you go in there and you're unprepared, and I've seen a public defender give what I thought was kind of lukewarm jury nullification argument. I thought that she didn't hit all those points, and I thought it would have been better if she could have. That was in the Rich Paul case. It didn't matter because the judge kind of swept it all under the rug anyway. But I think it's very important that you go in there and you say, I want to hit all these points. Because when they give you those instructions, they are not designed to educate you. They are designed to facilitate the system. And again, I'm a cynic, but that's what happens in most cases.
Hi, my name is Donna Priolo. My nickname is Bumps, and I live in Farmington, New Hampshire. My husband and I moved to New Hampshire in 2001 from San Jose, California, and I thought this was the perfect opportunity to introduce my husband, Rich, the new Rich, who has been identified as a criminal in New Hampshire for growing cannabis. Our jury trial selection is in November, and our trial is in December. This is a hard subject. It's exciting to hear everybody speaking, but this is in such a hard time in our life since October of last year. Our daughter, who's 14 and is here, you may have seen her, decided that she didn't like our rules in the house and that she wanted to live with a friend who had no parents and run around town, do what she likes. So she called the police on us. She's very sorry now. She's a good-hearted girl. We've gotten past that, and this has brought our family together. But we're going to need a lot of help and support coming up. We have Attorney Bob Zupkis of Rochester, New Hampshire, who has been highly recommended to us. Both of us, I've had breast cancer 2005, bilateral mastectomy. I have pain from head to toe. Maggie Hassan has taken out the PTSD and the home cultivation options for the new bill, and I'm so upset. Found out about it while we've been here at PorcFest. You know, he has been diagnosed with hepatitis C, which is in the bill. He has PTSD, he was a war veteran. I was sexually abused as a child for many years. I think we should still fight for the PTSD and, of course, recreational use. But for now, if any of you have any help or support for us, you know, we would greatly appreciate anyone's help.
Why don't we talk after this?
Thank you. I mean, we talk all the time about why this is so important, and it really is sobering when there's somebody standing in front of you that it's their life, you know? It's hard even when you work in the court. You become numb to it. It becomes like a conveyor belt, and you miss out on it. But I want to just take this little deviation just for 1 second to talk about why it's so important that you be involved. If you come to New Hampshire to apply the fullest, what's it called? Say it with me, the fullest practical effort to affect the law. This law would not be in place right now in New Hampshire if he wasn't Speaker of the House when it came up. He wouldn't have been Speaker of the House if people didn't go out and vote. You cannot be on a jury unless you vote. You have to be a registered voter, or now you also, another way to get in is to have a driver's license, okay? But when we spoke, I mentioned to him there might be a few anarchists mixed into the room here and there that don't believe in voting, and even our keynote speaker last night literally said one of the 5 things you should do is not vote. And I'd like you to speak just for a moment. You made a comment to me when I met you at your house about how New Hampshire is particularly susceptible to individual effort. And would you speak to that, please?
Sure. A lot of you know it. I mean, I see folks in the audience who are state representatives. And you know what I know, which is what everyone should know, is that in New Hampshire we have a uniquely open government. We have very small districts. You can get elected in a district relatively easy. You might have to decide whether you're going to be a Democrat or Republican based upon where that district is, but in terms of liberty views, you can go out no matter where you live and talk to people and get yourself elected. You know, I've lived here for about 30 years or so. I've only been active the last 10 years or so. I got active because somebody asked me to run for a school board. And I did. And then I started looking at what was going on in Concord and figured I've got to see if I can assist there. And within 2 terms, I spent 2 terms up there, and I was actually voted out 1 term. So not 2 consecutive terms. 3rd term, I became Speaker of the House. And I beat a state representative who was beginning his 16th or 17th term. And I did it because this is an open government. And now, you know, I know it can be very frustrating. I see Dan and George there, and we've all had conversations about how disappointing it is to lose bills, things that ought to be done. This bill was somewhat of a disappointment, because we would rather have a judge making the instruction rather than putting into law that it is the law. But, you know, you can make progress here. What we have now is a law that says jury nullification is part of the fabric of New Hampshire, is part of our laws, which means it makes it much more difficult when we get back in the majority and someone brings forward a bill and says, well, let's require the judge to give an instruction on the law. It's not as far as a journey as it would have been in just bringing it up new. So, you know, there's every reason to become involved here. You know, within 3 or 4 years of me becoming involved, I was chairman of the state party's platform committee, writing what the Republican platform would be. I then went on to become chairman of the bylaws committee, telling them how to run the party. Any one of you can do that. And I'm not a person of any special abilities, no special appearance, unfortunately. And any one of you can do it. Any one of you ought to step forward and doing it. You know, when I remember back in I can't remember when it was, 2004, I met Tim Condon, who probably a lot of you know, and he said, you know, you have any problem with these free staters coming? I said, please come, because you can change the state the way many of us are struggling, but the only way you can do it is by getting involved.
I had a statement that I hope will be helpful to everyone who is concerned about this issue, but before I do, a couple of notes. A, I've been a state representative. I've served with Bill O'Brien for the last 3 years, and I sponsored a bill that I think some of you would be pleased with called No Victim, No Crime, and pitched it on its merits in the House. We would not have been able to make that argument the way that we did if Bill O'Brien was not the Speaker of the House. And if you could take a second, I believe he deserves a little bit of standing ovation for that. The cause of liberty has not had as much potential in New Hampshire in maybe 100 years. But some people have tasted the possibilities. And for some of us, it's intoxicating. The bad news is that a juror was quoted on the Rich Paul case as saying, "I'm proud that we followed the law." They should be. What we should do is fix the law, but most of them don't know it. So I have a soundbite that I would like to encourage you all to think about. There's a book out, some of you might have heard of. It's called 3 Felonies a Day. Anybody ever heard of this book? This book says that the average professional, between the time he gets up and has breakfast in the morning till he goes to bed, will commit 3 felonies. Correct. Do those jurors know that they probably did? And do they really want to follow the law? Some sound bites and helpful points for you. There are 13,000 pages of legislation in New Hampshire, and whenever they want you, they're coming to get you. We need to communicate that to the jurors. We need to tell a story. That story is, it could be you and you don't even know it. Does the crime matter? I tried to have my ex-wife charged with adultery. It's a crime in New Hampshire. Go ahead, laugh, it's funny. Then the police wouldn't take a report. So I go to the State House. And I say, all right, the police won't charge anyone for this crime, so let's repeal it. I put in a bill to repeal adultery as a crime in New Hampshire. You guys probably heard about that, right? Crashed and burned. I couldn't repeal a law that no one will enforce. It's absurd. 13,000 pages of legislation and law and rule, and they selectively enforce it. Which one are they going to selectively enforce against every juror in that box at some time in the future? Because if you can cause them to fear that someday it's going to be them or someone they care about, and that they can take the power back today, then we can start a trend where juries are saying, we've had enough, and send a message to the legislature that says, let's clean this up.
Thank you.
Thank you.
So it was said that one concern was whether jury nullification would be equitable, like I'd say whites versus blacks. Although the thought that the thought that strikes me, however, is suppose, for the sake of argument, let's say for a given crime, whites are only convicted 50% of the time and blacks 75% of the time. Let's say jury nullification cut that to 70 and 10. So let's say whites benefited a lot more, but they both still benefited. So my thought would be, yeah, I would prefer if blacks benefited as much as whites, but it's sort of like when, let's say, the rich get a lot richer and the poor get a little bit richer. It's like, why complain? They're both getting better off. What's there to complain about? What would concern me more, and I wonder, I can't think of how this would be practical at all today, but I guess I'll ask whether you can think of whether this would be a concern, is, for example, in parts of the South, you'd have jury nullification was used by like lynch mobs to acquit whites of, not by lynch mobs, by the jurors judging them to acquit whites who had murdered blacks. And so I guess that would be an example of where, I guess it cuts both ways. I guess you can use jury nullification on an unjust law, but you can also use it on a just law. Now I have trouble thinking of any just laws today that's going to happen with, but I guess I'll ask you whether you can.
You know, you bring up an example that those who are concerned with this law and others, look at. Think of the three freedom riders in 1963 who were who were killed in Mississippi for trying to register blacks to vote. And they were able to pull out a indictment for murder for the suspects. And, the jury nullified it. A prejudiced jury said, we don't care. It was pretty clear they killed these black men. Actually, one was black and I think two were white, but they were freedom riders. Eventually, there was a federal trial for violation of the civil rights, and they were able to get a conviction. That's the concern, that some of the judges have. There is, again, I don't want to in any way minimize the arrogance of position. I've been Speaker of the House. I've been on the Supreme Court Rules Advisory Committee. I've sat with these people. I'm as aware of all of you as you are, how government acts in a very arbitrary manner, in part because people get pleased with power. And so I don't want to minimize that. But neither do I want to minimize the concern that justice should be blind to the defendant. Justice should not care that a defendant is an African American or a member of a disfavored group. And again, if someone comes up from Harlem in New York and is alleged to have broken the law, I don't want that person to be any more eligible for a conviction than if I break the law. And that's the concern they have.
I think it's important to consider that 12 people, once in a while 12 people are going to make the wrong decision, because clearly if somebody was harmed and they let their friend off, or these guys were doing this to protect someone, that's going to happen. But the flip side of that is, what, are you going to leave it up to a judge? I'd rather have 12 people who understand that they have this right judging me. And again, I go back to the relevant thing is, was her person harmed? You can't make a jury do anything. All you can do is provide them with this information. Most times, juries are going to say, if they've got the mindset of no victim, no crime, I don't care what the law says. I care that that person right there is charged with something, and he was selling raw milk to the guy next to him. Who got hurt here? No one got hurt. Make it go away. Occasionally, you're still going to have it. And I've had a prosecutor use the very same argument we just heard about, it was used, in the South, and, they let people off. Yeah, that's going to happen once in a while. But that doesn't happen with judges already now? I think it does.
And Kathleen, the case that you nullified, he was black, right? Oh, he wasn't?
No.
Oh, I just assumed.
Just because he was Rastafarian?
Yeah.
No, white man.
Oh, can I become one then? I thought you had to be born into that.
He'd been a Rastafarian for 35 years and talked about his conversion and so forth. He's a piano tuner.
Piano tuner. So from my experience in the courtroom, I was in the courtroom for about 17 years as a stenographer. I don't have a lot of fear about that sort of unequal justice under the law with us. But I think there will be, if you're a likable person, if you have a sympathetic story, if you're likable, your chances are going to be a lot higher than if you're a curmudgeon. I don't think it's going to matter what color you are. I think if you're a crotchety old bat, you're going to have less of a chance. Go ahead.
Yes, hello panel, thank you. Tom Ploget, I think you all know me. Hi Bob. Hi, Bob. Nice ride up from beautiful Grafton. Better than standing out in the snow handing these pamphlets out I did not see on stage. So I ran up to Grafton site and got a bunch of them. Just standing in line, Mr. O'Brien mentioned Tim, thank you Bill, another Graft night. Bob and I were 5 of 7 people who went to North Haverhill, stood in the courthouse parking lot, handing out information. You can do it in your own state. Federal courts are a little picky, we'll warn you right up front, but most states' courts tolerate the literature of FIJA, which I have here. I don't have an ANH jury, but I just want to let people know I have literature to hand out.
You want to leave it here?
Yeah. Can I ask you a question? Maybe this is a question to
Sure,
Bob
Bill.
as well. You mentioned the federal judges not being too sympathetic to this. Have you or any of the folks nationally ever been indicted for or charged with jury tampering? Because that's what some of the judges, when we had the bill in the legislature, saying, well, we can't have them doing this, jury tampering.
Bill, some of our allies, like Julian Heiklin, who used to be with us, had to leave he chose to leave the country. I think I'll let Bob. Bob, could you?
Yeah, some of you might know who Julian Heiklin is. He was a college professor in Pennsylvania and kind of a really cool guy. I don't think he's here this year, but he's been here in years past. And Julian used to go and just very quietly hand out at the federal courthouses. And ultimately, I think his charges were dropped because he was more of a pain in the ass to them than anything else. And I think that they realized he was going to go all the way with it. But I would say New Hampshire now, and Bill touched on it, we've got a toehold on this. And now it's going to be easier because in New Hampshire, we've already got this law, albeit it's a little weak. We want to strengthen it. But now all of the judges and so forth, they pretty much, even if they don't like it, they're not going to keep you from handing these brochures out in front of a courthouse. I had a prosecutor try to change my bail conditions for doing this, and the judge, who probably, I don't think liked me, told the prosecutor, no, we can't stop him from doing that. It's a free speech issue. So if I were handing out or trying to hand these out to my own jurors, this is what the judge decided, then I could possibly be jury tampering. But if I was doing this on a regular basis, which I was, and I was handing them out for you or for you, there's nothing they can do because it's under free speech. So if you are a defendant, maybe someone will show up at your trial and hand these out just because that's what they do. But the line, I guess, is you can't do it on your own because then the circumstances of your trial might come into it a little bit. I don't know if that answered the question or not, but.
Sean David Hesinger II, pro litigant and legal activist. I had my first trial in my first case between the 7th and the 8th of last month, and although I was too distraught by the illegal proceedings against me to speak before the jury during voir dire, I managed to get a hung jury. Anyway, with that in mind, my second trial is on the 8th of next month, and I was wondering if you could give me any advice on how to speak before the jury regarding jury nullification in a subtle manner.
Well, I'm kind of curious now. What are the charges?
One count of resisting, obstructing, or delaying a peace officer, and as of the 10th of this month, 2 counts of battery on a peace officer. It used to be just one when I litigated it in my first trial.
Well, I think we touched on a sympathetic jury, and the reason I ask isn't, I think it's important, the nature of what you're charged with understanding the way, because essentially you're selling yourself to the jury,
Right.
is understanding that, and I would focus heavily on the facts and try and discredit that. If you think that you're making headway with the jury, you probably want to then get into maybe there was no victim. If whoever
I was the victim.
I believe you. But if there was clearly a victim on the other side and you're charged with something, the person comes in there in a neck brace, they got bruises all over them and all that, I'd say that jury nullification is probably not the way to go.
I'm the only one who sustained physical injuries.
I would point that out.
I have it in evidence, so.
I would present a twofold defense, and I think maybe I'll let Bill take it from there, but I would deal with the facts, but I would also point out that you were victimized, and these people that you allege to have victimized, that they're on the job the next day, there's
no
medical
injuries
records.
whatsoever.
Right, I would point that out.
Yeah.
Do you have a lawyer?
No, I'm a pro litigant.
Pro se litigant.
In fact, the public defender's office even injured me as well, but that's a different story.
I hope not physically.
No, just mentally and legally. So I kind of had to do a bit to repair my case.
You have a right to ask for a different attorney in the public defender's office if there's a personality conflict or something that you can't work with the person that was assigned to your case.
After two attorneys, both of which were assigned to me without my consent, I do not trust the public defender's office.
I understand. I hear that a lot. Just my experience when I worked in the courtroom, I watched the public defenders all the time. And if I had ever been charged with a crime, I would want a public defender. Mark Sisti was a public defender, okay? They are some of the best criminal attorneys in the state because that's all they do. They don't do dog bite case on Tuesday and a slip and fall on Wednesday and my wife committed adultery on Thursday and then a simple assault on a police officer on Friday. All they do is criminal. All they do is criminal work. So you make your choice. You already got a hung jury. Maybe you're going to be fine. I always cringe when I hear people saying that they're not going to go in there with a lawyer because, I mean, at least a lawyer can help you with the facts. You can argue your own case. As a matter of fact, would you explain, he had his trial. He was charged with felonies, manufacturing, and he argued his own case, but he had a lawyer assigned to him, a public defender, that was there to answer legal questions. Could you just give us a really quick rundown about your experience with that?
I think it depends upon the individual. If you're comfortable speaking in front of people, any type of, and it's a sales job, that's what you're really doing. Mm-hmm. For me, once I made a decision, there's a whole, if you're charged with felonies, it gets into your head. Just like these folks over here, it's interrupted their life. It's going to mess with them. It's never going to be over. So when you get to a point in time where you've made that decision, I don't think that there's any cut and dry answer. I think it comes down to, can you present your case? Where are you in terms of your finances, in terms of what you're trying to accomplish? If you're saying, hey, I got a felony, but boy, if I could just get a misdemeanor, I'd be pretty happy.
I'm already charged with misdemeanors, so.
Okay, so I mean, that, in my way, the perfect, and I'll use a pot case as an example, the perfect case there for someone to take it all the way isn't a felony because there's a great deal of risk. I'm just stubborn. I think if somebody had a misdemeanor in anything, that's a great lab experiment. You also have to understand that you can lose, and there's a very good chance that you will.
I have a strong case for appeal anyway.
Right. So a lot of it comes down to how much you're willing to do, because I can't say that a lawyer will absolutely help you, absolutely hurt you. All I can say is if I were speaking to a jury and my last card was jury nullification, in my circumstances, would prefer to be the person doing that talking. But other people, they might be afraid or they just don't like to do that. So maybe then somebody who is familiar with that, maybe Bill O'Brien or maybe Mark Sisti, because this person says, hey, I just can't do this. I can't speak in public, and this whole process is intimidating.
Now, there was some mention of it.
Can I just say something? If you're having a jury trial, you must be charged with some misdemeanor A's, which mean that you can go to jail for a year on each one of them.
Right.
So that's why you have a jury. If there's no possibility of incarceration, you don't have a right to a jury trial. I think you ought to take up Leah and take Bob up on this suggestion. Go to the court and say, I'd really like to have an attorney just sitting there so I can turn to him and say, what does that mean? If someone says that, if the prosecutor says, I want you to give a Wentworth charge, Judge, you ought to be able to turn to somebody and say, what the heck does that mean?
So with the whole lawyer and the whole attorney sitting on the side thing, is that like within the meaning of Argersinger v. Hamlin?
I don't recall the citation you just came up with. What I'm talking about is your ability to preserve. You say you have a great appellate case, you have to preserve the appellate issues. And unless you do it, unless you object when evidence is coming in or you object to a charge at the right time, I've done probably 15, 20 cases in front of the Hampshire Supreme Court, and they love to say that wasn't preserved in the case, that issue wasn't preserved in the case below. Because, they want to avoid having to make law. They want to avoid having to do any work.
Well, actually,
they don't give advisory opinions. They change cases. They deal with cases. So, ask the judge, assuming the income is correct and all that, say, I just want a legal advisor there, just somebody who can sit there and I say, what was just said?
He wants some counsel.
Yeah, assistance of counsel.
Sixth Amendment assistance of counsel.
Yeah, right.
Right, preserving the Sixth Amendment within the meaning of Argersinger.
Yeah, right. I mean, and then you can, if you feel comfortable, argue your case yourself. I think in Bob's, I've watched the YouTube of Bob's closing argument, and I think he did a brilliant job. He really did. I mean, because he had an opportunity that a lot of criminal defendants don't have to present himself as a human being. And I think, as I looked at it, I saw that it was probably very persuasive in a jury. It says, he's just not a two-dimensional figure sitting at a table next to some guy who's a lawyer, and I don't like him for that reason anyway. He's a real human being charged with something that didn't harm anybody, and we don't want to do this to him. And so it can be very, very effective. On the other hand, you got to know what's going on around you.
Thank you.
Thank you.
Hi, my name is Pam Ian, and I'm a former police officer. And I have a bit of advice for anyone who is a defendant and is going to take the stand. I was always taught that as a witness for the prosecution, in my case when I was a cop, you always make eye contact with the jury. And that advice will work for anyone who is a defendant because it humanizes you. Even when you have a defense attorney in your face when you're on the stand, I always looked around him and made eye contact with the jury. And for anyone who is a defendant, as I said, you're going to take the stand, that's good advice.
Thank you.
Yeah, and again, those practical tips are something that a legal advisor should tell you, because I've seen pro se defendants, start doing things like, asking an empty box a question and then running around and answering it and going back, and you're not presenting yourself as somebody who's a real human being. It's kind of artificial at that point. So, again, get somebody to at least sit there with you.
Worked for Woody Allen, right? Bananas, back and forth. Yeah, and I think he got found not guilty in the trial.
At what point do bench trials become a concern? I know you had mentioned only Class A misdemeanors actually get jury trials, and in the same note, federal trials, I know have something like 99% conviction ratings. Are they a lot less suitable for jury nullification than state trials?
The federal laws are very different.
Yeah.
They're very difficult on a defendant. It's like they don't even have to give you a lot of the information that you're required to give a criminal defendant at the state level. I mean, if I remember right, you don't even necessarily see all the witnesses on the list that are going to be there against you, and there is no nullification law that's been passed at the federal level. But I don't know.
There is, as Bob would probably knows, there is some federal case law, federal cases, decisions, in which there appears to be an argument for jury nullification. So if you're in that situation, you can argue to a judge. In terms of the 99% conviction rate, that's probably because all the weak cases they plea out, and they say, well, we indicted you for 20 felonies, and this is what federal prosecutors always do. They just go crazy. And so they'll say, you can go to jail for 500 years, or, you know, if you accept this one felony and we'll plea it out, you can go to jail for 3 years. And so that's one of the reasons that only from a defendant's point of view, the worst cases go to trial. And I used to do a lot of defense work and civil defense cases, civil cases, defending them. And remember at one point I had a favorable jury record that went back like 10 years, and you know, I'd go and say, this is the reason, you know, I'm quite good at it. Nah, we just settled the cases I was going to lose, you know. And so that's what they're doing there.
Yeah, I just would like to add to what Bill said, that very few people will take a case to trial, and that serves the prosecutor and it serves the state. And this is my opinion, I think that the more and more that we have successes, even minor successes, I think that this is a very small state, and I think prosecutors know that. And let's say that this person here goes and he wins. Well, the next time they deal with you, like in the Rich Paul circumstance, they did not want Rich Paul to go to trial. That's why they offered him no jail time at all, when they could have thrown his ass in jail for, you know, a million years or whatever the heck it was. Now, he's a human being and he doesn't belong in jail at all for any of the things that they put out there. But what it really comes down to is the individual, because there is an awful lot of pressure put on you, because, you know, you just want to get up in the morning and do the things you normally do and hang out with your friends and do whatever it is. But you got this thing hanging over you. So if someone says, you know, we're going to run over your head with a lawnmower, or we might just punch you in the stomach, you're probably going to say, well, all right, you know, I'll take the punch in the stomach. They're never going to say there's a possibility that, you know, that you might win. And most people say, do this to me. So I don't know how it works on the federal level, but I imagine it's pretty much the same thing, that a prosecutor talks to you, your defense attorney, and says, well, you know, we might steal his house, or, you know, we're going to really dig in and ruin his life. So when you hear that they're only going to smash the windows of your house, you're pretty happy. And that's how they get all those convictions.
Thank you. Or did you?
My name is Drew Lauer. I was a prosecutor for a number of years and a defense attorney for a number of years in Washington State and in Colorado. And I want to talk a little bit about nullification as it refers to marijuana in particular, because I think that's how a lot of people are going to come into the system is with a marijuana ticket or a. Yeah, I'll start from the beginning. I'm sorry. My name is Drew Lauer. I was a prosecutor for a number of years in Colorado and in Washington. I've been a defense attorney for a number of years. I'm kind of on an extended sabbatical right now. But anyways, I want to talk specifically about marijuana cases, because I think that's what a lot of people are going to have. You know, that's a case where you really have a realistic chance of getting jury nullification. There's some real crimes, you know, kidnapping, rape. You know, you don't obviously expect that, but a victimless crime, great chance. The most common victimless crime is marijuana, and the punishments are really so it's insignificant in a lot of states. In Colorado, it was a $100 fine. Well, thank you. $100 fine, and you got some community service, but a lot of times the judge wouldn't even impose that. So there's such a minimal risk there. And my position was always, you know, everyone should fight these. You get a jury trial on that charge, even though they're in Colorado. So every state is different. So obviously you have to do your own calculus on this. But if you get a jury trial and your risk is a $100 fine, you know, go. Everyone should go. People be pleading out left and right. Okay, I'll take, and even for the maximum, you know, like they just deserved it. And I want to speak. Okay, this young man who was here before, just to change gears a little bit. One, if you have a criminal case, shut the fuck up. Don't talk about it to anybody until you get to trial, or you're talking in a confidential setting with your attorney. Don't get up in front of a crowd and start talking about it, for one. And here, his defense is self-defense. It's not nullification. So this is a situation where if you're going to represent yourself, you can still go and talk to an attorney. Take a few hours of his time. You know, you don't necessarily have to hire an attorney for the whole case for thousands of dollars, but at least go get some advice. Have him look over the reports. Maybe all the evidence should go away because they violated your rights and it was a legal search or something. At least, you know, it's not really for something you want to do completely on your own. But I also, in my experience, people who represent themselves in small cases, usually it's the prosecutor is pretty much brand new. The defense attorney is a brand new public defender, so it's maybe their second or third case anyways. If you're smart and articulate and passionate, that's all going to come across to the jury. And I've actually seen cases where it was slam dunk cases where people represent themselves and they ended up winning, where it surprised all of us. And it was simply, I think, because the jury felt sympathy for them for being in that situation. They think, well, this person can't afford an attorney. They don't really know the situation, but there's this individual up against the system, and that obviously garners sympathy in a lot of people's eyes. So I don't really have a question. I just wanted to point out some things. Thanks.
Thank you very much.
Okay, I just thought, you figure you all have some commentary. My question is, earlier you mentioned about Class A misdemeanors and felonies. I guess it ties into the same idea of the 3 felonies a day. I don't know how many people are aware of how many people suffer every day under like administrative law courts, and and just about how folks cannot, under those circumstances, avail themselves of juries. And I wonder if you would think that would do just as much a good job at nullification if somehow, through legislation, the legislature reined back in, of the housing courts, environmental control boards, whatever. If then there would be that many more jury trials, and also then again too, those folks would be sympathetic because we're arguing about kidnapping, but you can make up your ideas about what kidnapping is. If somebody's saying like, oh look, I only had 5 nails instead of 6, that person obviously can't be considered a threat to the community, and so then people would become more accustomed to the idea that so many people are being charged rather than just the kidnappers and arsonists and murderers and drug dealers and all that stuff. So if you think that would be effective, or if like prosecutors would even consider going along with that, if there'd be too much pushback, but if that's something that could pass through the legislature to just have everybody have their equal chance. Like if we were called in the Constitution, it says under any controversy over $25, and I know under environmental control boards, for example, you can be looking at $500 to $1,000 just for something stupid like your gutters aren't set the right way. So, that's all I mean.
I think the statement that you're making there is that administrative rules and all that having the effect of law, but it's like they're behind this glass window and you can't really get to them. I don't know the solution, but I would say if you feel that way, I felt that way too, talk to the state reps, and I think one of the solutions might be to get rid of some of this administrative rule having the effect of law.
You've touched on a real problem. And you've touched on so many different issues. There's a book that was actually published last week by a commentator by the name of Niall Ferguson, and he's talking about the degeneration of civic and civil society in the United States. Part of it is we're degenerating in a sea of overregulation. And part of the reason for that is that legislatures have turned over to administrators, to the bureaucrats, the making of laws. And we see layer after layer of laws going into effect, and it can be very oppressive. I think of 3 or 4 years ago, I represented a gentleman who was, I think in his 80s, had put up a sawmill back in the 1960s, about a year after the wetlands control law went into effect. And someone pulled out, 40 years later, 45 years later, a photograph and said, "Will you put that sawmill on what was wetlands?" And he said, "It looked like woods to me." And he said, "No, we have these, photographs, literally from 10,000 feet up, and that looks like wetlands." And he had his business shut down. He had 20 people working for him. They shut down his business. The Corps of Engineers, the Army Corps of Engineers was in there. The State Department of Environmental Quality Engineering was in there. The Federal Environmental Protection Agency was in there. And they basically held him up. They said, "We want you to, in order to get out of this, dedicate about 200 acres you own to the Trust for Conservation," whatever that group is. Give them an easement over it. Pay us $500,000 mitigation. This is oppression. And what you need to do is what we talked about before. Get yourself out there and be politically active. Don't wait till it happens to you. Get out there, be politically active. Let's have a less regulated society. We have to do it through our legislatures. We have to do it through Congress. You know, it's gone too far.
So we should probably wrap up in, I don't know.
Three more questions?
Yeah, 3. Let's just finish these questions off and.
Hi, I'm from Baltimore County Campaign for Liberty, and hope everybody can hear me. It's kind of one unorganized thing I have and one organized thing. The unorganized thing, there was a raid last November in a western Maryland county, and there was a guy who had a 20-year-old marijuana charge who, for some reason or other, they decided to come and hassle. They came in his house, found out he had 4 rusty 22s. But out of that bad situation, one of the people in that community went out and they formed town halls. Luckily, it didn't get in the media because that probably would have poisoned your community standards thing when you go for a trial. But fortunately, this guy went out to all the little town halls, went out to like all the 4-H groups, and made sure everybody in that county and all the surrounding counties that would possibly call as jurors knew about this case. And just to let you know, the case was being heard in April, and I was going to go to the trial. I got a phone call the night before. The Maryland State Police wanted no part of this and dropped all the charges against the guy and gave him like 30 days of house arrest. So that was a really good unorganized thing that turned into an organized kind of like under the radar effort. But my organized question is that I've given speeches at my Baltimore County Campaign for Liberty group about FIGA, F-I-G-A, and about people who, we have to break this attitude down that people do not want to go to jury duty, because even in my own group, people think it's a waste of time. And I'm just wondering if there's any advice you can give me about starting an organization or a group to go to the county courthouse and inform people outside of that. Thank you.
Sure. Why don't we talk after this? Tell you a little bit about how we got nhjury.com going, and it's really just grassroots. It's kind of like we put this big Oz thing up there, but there's really not much of us behind the curtain, so you could be up and running by next week if you're really serious about doing that. So let's talk about it.
Thank you.
And the other thing you might want to do, and Bob's doing some great work when it comes to trial juries, but most people don't realize the power of being a grand juror. A grand juror can order the prosecutor out of the courtroom, can issue subpoenas, can investigate anything it wants when it's sitting, any violation of a state law if it's a state grand jury. Grand jurors don't understand the powers they have, and unfortunately, the system has deteriorated down to the point where there's a lot of truth to the statement that we hear all the time that a good prosecutor could get a bologna sandwich indicted in front of a grand jury because the people don't know their power, don't know what they're supposed to be doing, don't know the history of the grand jury, which was putting citizens between the king and jail.
I'd be interested to hear any comments on what you think is our strategic position at this stage on this issue. It seems to me there's a little bit of 2 steps forward and 1 step back, both in the legislative history and also Rastafarian was good and the Rich Paul wasn't so hot. So reading the crystal ball, where do you think we're at this stage? And if you wish, any further ideas about what strategically needs to be done next to move the ball forward?
Well, we may find out with Rich Paul's case that we're in better shape than we think we are, because if that State versus O'Bear case is applied and that they had to read the jury nullification to the jury, that's as good as if it was written into the law. Case law is law. Is that right?
Sure, but to answer your specific question, you reach to a larger understanding of how laws are made. They're made over time, and perhaps it's good that way. We sit there and we say, all of us agree, and this is a little bit like an echo chamber. We're all agreeing with each other, but there's others out there who don't agree, and so you have to bring them to the point where they will, and you have to listen to what their concerns are along the way to make sure you're not making bad law. So laws should evolve over time. I see an evolution here where, 10 years ago when this first came up, people were saying ridiculous. Then 2 years ago, they said, not so ridiculous. Let's pass a law that at least, and that's where the Senate was, at least allows a defendant to mention this right. Then, 5 years, 10 years from now, based on that law, we get one that says we want, if a defendant requests, a judge to instruct on that. So, it is frustrating. It is unfair to people who are not going to be able to get that judicial instruction. But it's intrinsic in a what should be a very cautious process, which is enacting legislation.
So I just wanted to just very briefly bring up the difficulty in representing yourself, and I think you guys have brought that up. And I just, from a personal basis, I had a 2-day jury trial for going to see my daughters play ice hockey. So they were in a varsity ice hockey team. My ex-wife was there, and there was a restraining order. So I went to the jury trial. I decided to represent myself. I was kind of up to here with lawyers at that point in time. And, I would say I'm kind of uniquely qualified, but more than most people, to represent myself. I had a training company. I was used to standing up in front of people all of the time. I had represented myself in front of a conservation board one, in front of for divorce. I had been represented myself there. But when you're there and you're on trial and your possibility of going to prison and you're just being brought up as this really bad person, it's just a very emotional situation that can make it difficult to do as good of a job as you think you may be able to do. Plus, it's your first time, right? So I think if I did it again, I probably could do a much better job, but being that first time, you make lots of mistakes. And those mistakes can very likely or may cause you to go to jail for some amount of time. So you really do need to think about that. I'm not big on the public defenders. Some of them may be good, some of them are very bad, but you really just have to keep that in mind.
Last question?
Last question.
Make it a good one.
It's more of a statement than a question, and it has to do with voir dire, the questions you're asked.
That's French for jury tampering, right?
Right. V-O-I-R-D-I-R-E, voir dire. FIJA, a long time ago, before Ilolo Jones was in there, came up with 4 legitimate questions that jurors could be asked. I don't have all 4, but it's something like, do you know the defendant? Have you ever been involved in a similar experience? Do you have the time to vote? I don't remember what the 4th one is. But you have to realize that the voir dire that you fill out is for the government's position. It's not for the defendant. So you don't owe the judge the truth when he asks you if you'll take an oath to support what he says. There's something called a mental reservation. When you're asked something, can you support this position that I'm going to tell you about? You can say, yes, I can. And mentally, in your mind, you can say, if it does not go against my conscience.
I would suggest using these words, yes, I could, which also implies I could not.
Right, exactly.
Like the difference between must and should, right?
What is the meaning of is?
So you don't owe them the truth.
Yeah, that's the juror's Wentworth instruction.
Thank you very much. I know I mentioned to a couple of people I would like to talk to you after, and I appreciate everybody in the audience. And I do have some brochures, and if you see me wandering around later today and you want some information, I know you were thinking about starting your own thing, which I commend you on that. And thanks for being here.
And thank you for the panel, all their time. Any questions?